Good afternoon, everyone. Thank you for joining us today for our webinar on immigration enforcement. My name is Anthony Bowman. I'm the Community Partners Network Manager at Asian Americans Advancing Justice, AAJC. Today is part 2 of our 3-part summer webinar series on immigration enforcement. Immigration enforcement is a complicated issue, but it's something that we should all care about because it impacts our civil and human rights. We hope that providing more information and background about our immigration enforcement system, what it is, who the actors are, how it impacts our communities, more community members will be encouraged to engage in efforts to reform the system for the better of all immigrants. Today's segment will focus on crimes and detention. We'll discuss what sort of criminal convictions or crimes can make someone deportable, even if the individual is a lawful permanent resident or the incident happened decades in the past. We'll also discuss what crimes lead to mandatory detention, what the civil immigrant detention system looks like, and current advocacy efforts to curtail the use of immigrant detention. Today we are joined by 2 presenters. First is Purna Lau, our staff attorney for Immigration and Immigrant Rights at Advancing Justice AAJC. Our second presenter is Carol Wu, a research and advocacy associate with the Detention Watch Network. Purna and Carol will present for approximately 30 minutes. After the presentation, we will have time for Q&A. We will use the questions feature on the webinar to collect questions from participants. Because so many of us have joined the webinar today, all participants will be kept on mute for the duration of the webinar to minimize interference and background noise. A couple of final notes. First, we are recording this webinar and will post it online afterwards for your reference. And lastly, the information presented today is for informational purposes only and does not constitute legal advice. And consequently, we will not be able to answer questions that look at specific cases. Now, without any further delay, I will turn it over to Purna and Carol for our presentation.
Thank you, Anthony, and welcome everyone to the webinar. So I'll start off talking about immigration and crimes and how immigrants have long been associated with criminal behavior, including immigrants from Asian countries and our communities. If we look back in time, we had Chinese immigrants to the country who were treated as if they were criminals and prisoners. They were locked up at Angel Island for days, if not weeks, before they were either deported back or very few were allowed into the country. So we can see the sort of the beginning of immigration detention with the Chinese Exclusion Act. Chinese laborers were viewed as foreign invaders, and they were excluded for things like quote-unquote sex work, health, becoming a public charge, or threatening to practice polygamy. And these charges were sort of used to exclude many Asians and Latinos from even entering the country. This cartoon is about the Japanese, actually, and the internment of Japanese Americans during World War II, how they were seen and viewed as national security threats and put into internment camps across the country. There's also been very recent efforts to detain Muslims, Arabs, and South Asian Americans who are perceived as Muslim, especially after 9/11. There was a whole DHS program called NCS, which rounded up and deported 13,000 persons from these countries that you can see on the chart. None of those people were actually terror suspects or so-called terrorists. They were actually mostly people who had overstayed a visa. But it had a devastating impact on immigrant communities in the U.S. And finally, this is a cartoon that talks about how there's so many perceived threats when it comes to immigrants. There's nothing to fear but giant mutants who are Ebola infected and ISIS terror, drug cartel, illegal, so and so and so, who are now perceived as threats to the country. So that's the background of, immigrants being sort of viewed as criminals and threats, of course. But crime rates have no correlation with the presence of immigrants in the U.S. If you look at, we have about 11 million undocumented immigrants in the U.S., and a very small portion of them have committed crimes or have any sort of convictions. An even smaller portion of them are removable, and then an even smaller portion of that are what is called an aggravated felon. A report published by the American Immigration Council last week found that immigrants, whether they are legal or unauthorized, and no matter what their country of origin or education level is, are less likely to commit crimes in the U.S., and that periods of high immigration correspond with lower criminal crime rates. And this has been true in this country as long as this issue has been studied. Now, although these graphics address the growing misconception that immigrants are criminals, the narrative that immigrants are not criminals implies that there are others, that the others are in a way that fails to reflect the racial and social inequities present in the criminal justice system. When we do compare immigrants to Americans born here to state that immigrants commit less crimes, we are in effect throwing black people under the bus. But our communities are stronger together when we work together to end racial profiling and the hyperpolicing of our communities. And we'll sort of talk about the impact that this hyperpolicing has on immigrants in a little bit. So immigrants face increasing criminalization in the U.S. despite the fact that a visa overstay is actually not a crime. It's a civil violation. However, there have been as many as over 2 million people who have been deported, many with minor civil infractions in the past six years or so under the Obama administration. The actions of one immigrant is often made to reflect on the actions of an entire community. I'm sure many people have heard about the tragic shooting in California lately and the efforts underway to pass stringent and punitive laws in California that would make it harder overall for immigrant families to actually live in the state. But the actions of one person shouldn't reflect largely on the actions of an immigrant. As you can see here, deportations have been at a historic high over the past 6 years. More people are being removed at the border, but these are people who have actually lived in the country for many, many years and have family here. Despite political rhetoric, most of the deportations don't involve people who have committed serious crimes, and many people are actually deported without ever seeing an immigration judge. Also wanted to mention the fact that immigration status violations such as false claim to citizenship, illegal reentry, working with a fake social security number, voting, driving without a license are being treated as actual criminal offenses. You can see this chart here that sort of shows the rise in illegal reentry convictions, which basically means unlawfully entering the country after being removed. We briefly touched on what is called Operation Streamline in the first webinar, but basically the U.S. used to have a catch and release policy when it came to deportations. But under the Bush administration, we started to catch, convict, and then release people deep into Mexico, Central America. So that now most prosecutions in federal criminal court are for unlawfully entering the country as opposed to like drug trafficking or smuggling or any of those other more serious things. So there's been a more than a 400% increase in illegal reentry conviction in the past decade, which is really problematic because a lot of our federal prosecutions are now just basically immigrants being convicted for unlawfully entering the country and then made into felons. The other problem that's happened over time is that the list of crimes for which someone can be excluded, as in never allowed to enter the country in the first place, and also deported, as in removed, has grown over time from, say, controlled substance violations in the 1980s to actually now encompassing things like filing a false tax return today. There have been various laws passed over the last 20-25 years that have increased the list of crimes from just serious crimes to then drug-related crimes to offenses related to firearms or destructive devices to creating this thing called this category called aggravated felony to include money laundering, certain crimes of violence, foreign convictions, drug use, illegal smuggling, but also this list also includes things like stealing mail or lying on a tax return or not showing up to court. And also voting actually. So we'll discuss more in terms of how this is impacting immigrants when we talk about some of the stories of immigrants who have been deported because they are seen or viewed as felons. This chart here actually shows who's being deported and for what reason through the court system at least. The overwhelming amount of deportations still include people who just have immigration status violations, 31%. The next category is drugs, which is 15% of removals are for controlled substance violations, such as possession of marijuana and cocaine and so on. Traffic offenses are also a huge number of offenses. This is another way of probably saying driving while black or brown and then being arrested for driving without a license or having false paperwork on you, or no paperwork on you, really. And then assault makes, the first sort of serious crime on this list, but that's only 10% of deportations that come from those crimes. And then you can see that like less than 15% of deportations are for any sort of criminal activity. And then there's a huge unknown here as well on this list where there's sort of no crime or maybe status violation. We don't quite know. An important thing to remember here is that the Department of Homeland Security, DHS, sort of mines the criminal justice system for people to deport. But the latest research shows that this process is flawed since citizenship, or like someone's nationality is actually the most salient factor when it comes to sentencing somebody for crime in a criminal court setting. So it's important to note that many immigrants and people of color are on many occasions falsely arrested based on their appearance and limited language skills, and this leads to tougher sentencing practices for them. So what could have been a low-level offense, such as a fine and some days in jail or prison, ends up triggering a deportation because the immigrant is sentenced to over a year or more in jail, which then makes them removable from the country, as opposed to just having a fine and some days in jail, which not necessarily would have triggered a removal. Undocumented immigrants, asylum seekers, and lawful permanent residents are all subject to detention and deportation. It's not just people who are here without papers, but many other people who have lived here for a long time and lived here actually lawfully for a long time. So we'll go over some of these cases. This is Lundy Coy. She came to the U.S. as a refugee from Cambodia when she was 1 year old. So basically grew up here as an American and as a lawful permanent resident since she was a baby. When she was in college, she was caught by an officer with some pills of ecstasy and was arrested and convicted of possession of those drugs when she was 19, but could not be deported because Cambodia refused to issue sort of a travel document for her, given the fact that she was actually not born in Cambodia. She was born in a refugee camp elsewhere. So Lundy was detained and threatened with deportation for about a decade before ICE closed the case. But she still has to check into ICE every single year. Farhan came to the U.S. from Pakistan as a lawful permanent resident when he was just 5 years old. In 1995, when he was a sophomore at Rutgers University, he was sort of entrapped into giving 3 tabs of LSD to an undercover police officer. He wasn't the one selling the drug. He basically knew how to access it, and so he helped the police officer access it. And for that, he was arrested and convicted. He ended up serving 5 years probation. He paid a fine, and he thought he was done with it until 2010, just 13 years later, when I showed up at his door to pretty much detain and deport him for a $15 drug deal that he had done when he was in college. And Farhan was now 35. He was the father of 4 U.S. citizens. He was married to a U.S. citizen. He was detained and threatened with deportation to Pakistan, a country he had left, 35 years ago. So he is still fighting deportation to Pakistan today. Another thing that triggers criminal conviction, a deportation through criminal conviction, is tax fraud or filing a false tax return. This is actually a Supreme Court case called Kawashima versus Holder, where Mr. and Mrs. Kawashima had been living in this country as lawful permanent residents since 1984. In 1997, Mr. Kawashima was convicted of filing, and as well as his wife, a false tax return for his business. And him and his wife basically fought deportation for more than a decade and took this case all the way to the U.S. Supreme Court, which ruled in 2012 that filing a false tax return was an aggravated felony and pretty much upheld their deportation. So after living here for 30 years, the Kawashimas were basically deported to a country that they haven't seen for 30 years. This is one of the cases from our affiliates, Nanhui Zhou, who's a mother of a U.S. citizen. She basically was in an abusive relationship, and she called the police but did not get the help she needed. So she took her child with her back to South Korea, and she tried to come back with the child. She was basically detained, charged, and convicted of child kidnapping her own child. So she's still fighting her deportation in California right now. And finally, there's a case of two asylum seekers, Manoj and Maninder, who came to the U.S. seeking asylum all the way from India after India criminalized homosexuality again. And they were detained for many, many months before they were able to be released, actually. So it was, for them, the experience was they were persecuted in India, and they came all the way to the U.S. only to face more persecution in a prison while they're trying to claim asylum here. And now I'll turn it over to Carol, who will talk more about crimes that lead to the detention of immigrants, the conditions in detention centers today, and the current trends.
Thank you, Prerna. Can you hear me?
Yes.
Okay, perfect. So the first part of this is the question is, when is detention mandatory? Mandatory detention is defined as compulsory immigration detention, and that basically means that you have to be detained by law for certain reasons. Now, there are three primary buckets under which you can be mandatorily detained. The first one is if you are placed in removal proceedings. The second one is if you've received a final order of removal. And the third one is if you come to the U.S. border seeking admission without prior approval. And this sometimes includes potential asylum seekers. So customarily, when someone comes to the U.S. border and requests asylum, they are paroled out after receiving a positive credible fear interview determination. However, we've seen this being recently trumped by the recent entrant status under detention priorities, which we will discuss later. Next slide, please. So, okay, so actually, before I get there, it is very state-specific when it comes to determining whether a crime makes you deportable. You may have heard of the phrase crime involving moral turpitude, which is a very broad federal term that, according to the State Department, includes fraud, larceny, and intent to harm persons or things. It has also been interpreted by the Board of Immigration Appeals to be where the crime shocks the public conscience as being inherently base, vile, or depraved. This is an extremely nebulous term that has been interpreted and reinterpreted multiple times at many different judicial levels. So on a more concrete level, these crimes actually include anything from stealing a purse to lying under oath to filing a false tax return, as Prerna mentioned, and also includes animal fighting. So the next question is, who is a detention priority? Under Obama's November 20th executive action, there are three enforcement priorities. Under the first one, this includes basically anyone apprehended at the border while attempting to enter unlawfully. This also includes people who are at least 16 years of age who have participated in an organized gang, and this is with or without a conviction. So this means that you could be a potential asylum seeker and be fleeing gang violence, but because you have admitted to participating in some type of organized gang activity, you are a detention priority. Under the second priority, we have things such as significant visa abusers, which includes people who overstay a visa or people who have falsified information on visa applications. This also includes what they call significant misdemeanor conviction. Now, this covers everything from domestic violence claim, burglary, unlawful possession or use of a firearm, drug distribution, trafficking, and it also includes driving under intoxication convictions or any other conviction where a person was sentenced to more than 90 days. So anecdotally, we have actually heard that people with very old DUIs are being picked up by ICE. And this includes people who have exited the country and re-entered the U.S. on a regular basis in the past. So someone who may have come across the border multiple times and has had regular interactions with ICE officials and had no problem. And suddenly, because of these detention priorities, they're getting picked up and detained. So the third bucket is individuals with a final order removal on or after January 1st, 2014. So in some new developments, ICE has released policies in March where people with criminal convictions are having an increasingly difficult time of getting released, even on bond and parole. This is actually following a two-part congressional hearing in February and March in which there were testimonies of two witnesses whose family members had been killed by people released from immigration detention. So the Phoenix and Atlanta field offices announced a no-release policy for immigrants with any criminal convictions. And as Prerna referenced earlier, even more recently, many of you have read, San Francisco's sanctuary status has come under fire with a proposed Cates law that would actually provide a mandatory minimum sentence for people who re-enter the U.S. unlawfully. So on to conditions in immigration detention. The U.S. has more than 200 immigration detention facilities nationwide, and many of them are located in isolated regions that are far from major metropolitan areas. This is a problem because the major metropolitan areas are where there is the largest support from advocates, nonprofits, and pro bono attorneys. And as we know, your likelihood of winning an immigration case goes up spectacularly when you are actually represented by an attorney. And frequently, immigrants are actually housed in local jails in agreements between counties and ICE. So immigration detention is a civil detention system, but it is both penal and punitive, with people often spending extended periods of time in prison beyond criminal jail sentences. So you have people who have already served a criminal status who are being jailed for even longer purely because of their immigration status. And just recently, so this graphic that you're seeing right now was released last year. But recently we have heard of someone who was released from immigration detention after more than 9 years. It's also interesting to note that anyone who is not a U.S. citizen can be held in immigration detention. But there are documented cases of U.S. citizens being detained and deported. So the next thing up is our current detention trends. The first one is addressing the growth of the private prison system. So 62% of immigration detention beds are in facilities operated by private companies, and the two major corporations benefiting from this are actually Corrections Corporation of America, CCA, and the GEO Group. So to give you a brief background, in the late 1990s, CCA and what was formerly GEO, the Wackenhut Corporation, if you're interested, were in dire financial straits. They were close to bankruptcy and were bailed out by the now defunct hedge fund Lehman Brothers. So CCA and then GEO saw an opportunity post 9/11 in expanding immigration detention as a potential cash cow. So today, together, CCA and GEO have a combined revenue of $3.3 billion, which is astronomical. They also spend records amount of money on lobbying and in supporting specific political candidates. The second detention trend that we'll talk about is the national detention bed quota. Some of you might have already heard of this, but this is language inserted into the annual DHS appropriations bill, and it states that 34,000 detention beds must be maintained at all times. So to give everyone a brief background of how this came about, the language was first introduced in 2009 by then Senator Robert Byrd, who, interestingly enough, used to be a high-ranking member of the KKK. Now, he passed away shortly after he introduced this language, so there's actually no understanding why he came up with this number and why this language was inserted in the first place. But the mandate has been interpreted at various times as requiring all of these beds to be filled. But I think it's important to note that this is an arbitrary number. So even if there are not 34,000 immigrants being detained on a daily basis, the very fact that we still have so many people in immigration detention is a problem. The next detention trend is how the national detention bed quota is playing out at the local level. So this is through guaranteed minimums, and guaranteed minimums are contractual provisions in which ICE is obligated to pay for and for all practical purposes to fill a certain number of immigration detention beds at facilities. So far, these local lockup quotas, as we're calling them, have only been found in contracts with private companies, and there is current legislative efforts to get rid of this practice. However, there is a general lack of transparency by the government and its partners in this business, and so we actually don't have a full comprehensive view of where all these guaranteed minimums are. DWN has identified them in 16 facilities so far, but we actually believe that this is a bigger problem than what we have found. And that actually can be shown in the next graphic. So all the different colors are the different field offices, and there are guaranteed minimums in half of all of ERO's field offices. So the last detention trend that we're going to talk about today is advocacy efforts to end detention. And we're particularly concerned in terms of vulnerable populations such as families and for LGBT immigrants. So according to Johnson, Secretary Johnson, 50% of families are detained for a month and 30% are detained for more than 2 months. But ICE recently released new policies, and they're supposed to help asylum-seeking families. To say the least, these new policies do not go far enough and do not do enough, and basically are just conforming to the legal standards that are current right now. There is a lot of movement in the campaign to end all of family detention, building on a New York Times article that some people may have read, as well as a New York Times editorial that questions all of immigration detention. There's a lot of faith-based advocacy. There's also current litigation and a lot of legislative efforts to make this come about. So in recent updates, in following with these new policies, we have been seeing families being released from all 3 facilities at Berks, Dilley, and Carnes. But I'll hand it back to Prerna to talk about LGBT movement.
Thank you, Carol. As for LGBT immigrants, there's been a lot of movement in the past few months, if not years, to basically try to release, especially trans immigrants who are more subjected to isolation as well as being held on their own in cells, as well as sexual abuse in detention facilities across the country. And ICE has, recently issued a new memo, basically laying out, it's a huge 18-page memo, laying out ways in which, trans persons can be subject to either release from detention as well as given health care and be identified in the first place as male, female, or trans. And while this is progress in terms of how trans persons should be treated, it still does not go far enough in terms of the detention of trans immigrants as well as LGBT immigrants. So it's something to keep fighting for and fighting towards. We'll now move on to any questions and answers that people may have. They can put it in the questions box at the end here, and we'll answer them as they come in. If anyone has any questions also after the webinar, they can reach out to Carol, and her information is on the screen, as well as me at our email addresses.
Okay, our first question is from someone who wants to hear a little bit more about changes to family detention.
Carol, could you take that?
Yeah, sure. So I can tell you the new policies that were released by ICE in May and also at the end of June. One of them is that ICE promises to review cases for families detained more than 90 days. They also have promised to discontinue the use of general deterrence as a factor in the initial custody determination. And this was actually brought about by litigation. They've also promised to create a federal advisory committee of outside experts. We still have yet to see movement on this, and we have no idea what it's going to look like. ICE is also undertaking additional measures to ensure access to counsel, social workers, educational services, medical care, etc. But again, we have no idea what this is going to look like. The other thing that ICE has also promised to do is to release families with appropriate bond amounts or other conditions of release for families with who have set up a credible fear interview determination and passed that in the initial case for asylum. So, I mean, as far as these policies go, it's great that ICE is implementing them right now, but you know, we are afraid that family detention isn't going to end. They're just going to keep families for shorter periods of time. And that being said, it's still extremely harmful to children as well as to women who are seeking asylum who have experienced a tremendous amount of trauma back home to be detained for any period of time. So I think it's important to remember that despite these policies, there's still a lot of work that needs to be done. I'm not sure if that answers the question.
I don't know about that. Let's answer the other question first.
Okay, so our next question is, if a U.S. citizen is deported, what are the usual groupings?
I think it means grounds, actually.
Grounds, okay.
Okay, I can take that question. Well, first of all, U.S. citizens should not be deported. If they are deported, it's a mistake. But it usually happens, I mean, at least in the general cases that I have seen, if somebody has sort of grown up in the U.S. but doesn't have any proof that they are a U.S. citizen, because they, became a U.S. citizen just by derivative citizenship, like when their parents became a U.S. citizen but didn't get the paperwork for it. That happens quite a bit. I think there was a really famous case of ICE deporting a 4-year-old girl a couple of years ago. It took a lot of efforts to get her back to the country. It was because they also don't believe somebody when they say that they are U.S. citizens sometimes, and there's such a lack of due process in the criminal justice and immigration system, at least, that sometimes people want to prove they have no, that they are U.S. citizens, but either don't have the time or resources in detention to prove these things. So, I mean, that's usually how U.S. citizens get deported. There's a great blog called States Without Nations, which actually tracks the deportations of U.S. citizens and the numbers and the stories. It's ran by Professor, I think, Jacqueline Stevens. So definitely look it up. It's States Without Nations if anyone is interested in sort of the deportation of U.S. citizens.
Everyone, we still have time for more questions, so if you do have a question to submit, please do so using the question features. And just a reminder, we can't answer any questions that might constitute legal advice or that are regard to specific cases. I received a question, or a request actually, from someone who would like for us to go into more detail about past crimes and coming back and picking them up.
Basically, in many cases, sometimes this happens. Let's see. There's several scenarios under which this can happen, right? Say somebody serves their time after a criminal sentencing and is released into the community, and ICE is not notified about it, or is basically not doing their job. So years later, that person, tries to renew their green card, and ICE figures out that, wait a minute, this person has a conviction and therefore is not admissible, they should be deported from the country. So that's when they show up at your door sometimes, or send a notice to appear for proceedings to resume in immigration court. Sometimes it happens when, say, a lawful permanent resident travels abroad and then comes back to the country, and the CBP officer, the Customs and Border Protection officer, sort of sees, that this person has a conviction or two from 1980, 1990, whenever, and basically then takes their green card and puts them again in proceedings before a judge to then fight their deportation. So that's sort of how old crimes come back to bite somebody, especially somebody who's a lawful permanent resident. And I'm sure there's other examples as well, and coincidences that happen too. But the biggest problem with this is, of course, that some of the crimes are retroactive, as in these it became increasingly punitive over time, whereby people today are being deported for crimes they've already sort of served their time for, paid the fine, and it's coming back to bite them, basically, even when they thought that it wouldn't come back to bite them, and they didn't know the consequences, the immigration consequences of pleading to a certain crime back when they did. And then these crimes became, crimes involving moral turpitude, or became seen as an aggravated felony, or some other crime that DHS does not like. And then what happens is, then these crimes have immigration consequences. Somebody wants me to repeat the name of the blog about the deportation of U.S. citizens. It's called States Without Nations by Professor Jacqueline Stevens. So if you have additional questions about it, you can also email me after the webinar.
All right, we have a question, rather complicated one. Are there many metrics in place to identify gang members from foreign countries? Criminal records do not appear to show whether or not someone identifies as a gang member. So how do we identify gang members from other countries?
I don't know if Carol wants to take that, but as far as my knowledge goes, we do have an extensive sort of quote-unquote criminal gang database, and there's a lot of mismatches on it, as well as a lot of just suppositions. It's not actually a database that is like, you were convicted of a gang, sort of being part of a gang. It's more of, these people are suspected of gang membership. A lot of it is through racial profiling, to be honest. And it's not very accurate as well. So if we use that database to then base our convictions off of, we don't really lead to the best results. I don't know if you want to chime in, Carol.
Yeah, no, I mean, we've also heard anecdotally that, having a tattoo can make you seem like you are part of a gang. And so, again, going towards what Prerna was saying in terms of racial profiling, it is very subjective. And you don't need a conviction in order to be detained under that priority status. So it's basically like they think that you participated in gang and they're going to detain you.
Right.
Okay, do we have any more questions from anyone? Okay, well, we don't appear to have any additional questions, so that concludes the Q&A portion of our webinar today. If you do think of a question after the fact, please, get in touch with Prerna and Carol. Their emails are still on the screen. That concludes part 2 of our summer webinar series on immigration enforcement as well. We hope that you found the information we shared today informative. In the coming days, we will be sharing a short follow-up survey with you so you can tell us how we did. Please do share some feedback with us. We will also send out a link to where you can access this webinar, which has been recorded online, so that you can share it with others or review the information for your personal use. Remember to save the date for part 3 in our summer webinar series, which will be held on Thursday, August 13th, 2015. Part 3 will look at efforts of advocates to push back against unjust detention and deportation. It'll be a great opportunity to find out how you can get involved in your own community to fight unjust detention and deportation practices. Thank you again for joining us, and we hope that you have a great week.
Thank you.